why the trial judge in our case needed and was entitled to determine what happened before he could decide whether the standard of care was breached by Dr. Ward. Our friends agree at paragraph 10 of their factum that in some cases, it may be acceptable to consider the nature of injury as circumstantial evidence when it is necessary to understand the course of the events. However, they go on to submit that the nature of the injury is not relevant to whether Dr. Ward upheld the standard of care. Respectfully, without looking at the injury, the trial judge would not have been able to evaluate the different explanations presented at trial for what caused the blocked ureter. Those explanations being that the theory put forth by Ms. Armstrong was that the injury occurred as a result of a ligature being used within 2 millimeters of the ureter, and the theory put forth by Dr. Ward was that he stayed 5 to 15 centimeters away from the ureter while nonetheless causing the scarring. With these different explanations presented, it is clear that the trial judge needed to first determine what happened to decide how Ms. Armstrong's ureter was damaged and whether that constituted a breach of the standard of care. The trial judge accepted the evidence that the thermal injury sustained showed that the ligature came within 2 millimeters of the ureter. The thermal injury was evidence of what happened, and this evidence was crucial in determining whether the standard of care was breached. The injury...
Couldn't the evidence of the thermal injury also support a conclusion that this was just an error in judgment or surgical misadventure as opposed to negligence?
So I guess you could say it could. However, that was not raised at trial. So there was no explanation given for how Dr. Ward could have come within 2 millimeters of the ureter and nonetheless caused this injury. The only two theories that were presented was that he stayed 5 to 15 centimeters away and nonetheless caused the scarring. However, the trial judge rejected that theory based on the evidence that was presented by the expert testimony and accepted the theory that the appellant put forward, which was that the ligature device came within 2 millimeters. So the injury did not define the standard of care. It informed the trial judge of what happened. So to conclude, causation, specifically determining what happened, can and in some cases must be used as circumstantial evidence to inform the standard of care. So subject to any questions, that concludes my submissions.
Counsel, what is the difference between stating that the standard of care requires staying 1 to 2 millimeters away from the urethra versus saying that it requires protecting the urethra?
Yeah, so there was 3 things said. So they had to identify, protect, and stay 1 to 2 millimeters away from the ureter. And basically why that was done was because if it was simply to identify and protect the ureter, the question would be, okay, well, how do you protect the ureter? Which would have led to some ambiguous around that. So that is why that third step was decided and was put forth with expert testimonies that to protect the ureter, staying 1 to 2 millimeters away was how you could do that. And that was the only way you could protect it.
Thank you.
Ms. Murray, I have a question about the relationship between steps and goals. At what point do they cross over and what point are they different?
Sure. So from our submissions, we would say that steps and goals are, they basically draw the same meaning. So any step could be considered a goal. And the trial judge wasn't giving like a goal-oriented steps. They were what you had to do to achieve the standard of care. So, from our perspective, any step could be a goal.
So just to reaffirm, would that mean that reaching and adhering to the standard of care was the goal, or was that a step?
I think I would say standard of care is what is required, and those were the steps put forth that the surgeon would have needed to achieve. So he had to meet every one of those steps to meet the standard of care.
Thank you.
Perhaps we can hear from your co-counsel now if there are no more questions from the bench.
Sure, I can get started. There's no more questions. Just want to check. Okay, great. All right, I'm Kirsten McCann. So moving to our third point. Our third point will answer the question of whether Mrs. Armstrong, as the plaintiff, had the duty to rule out potential non-negligent causes of her injury. As our friends have stated at paragraph 16 of their factum, this case does not require the plaintiff to rule out non-negligent causes. The notion that it does, that was put forth by the majority at the Court of Appeal, imposes an unjust standard on the plaintiff because it suggests that it is the plaintiff's duty in medical malpractice cases to rule out every imaginable non-negligent cause. The only potential non-negligent cause of injury raised at trial by Dr. Ward, the defendant, was the theory that despite having stayed several centimeters away from the ureter with the ligature, injury still occurred. The trial judge rejected this theory correctly because no expert witness testified that it was possible for a reasonably competent surgeon staying several centimeters away from the ureter to have caused this injury. Other possible causes, such as lack of dexterity on the part of the surgeon or the unexpected movement of structures during surgery, were theories only brought up on appeal. These theories were not put to any expert, nor was any evidence of them brought to the trial judge or the plaintiff's attention at trial. Neither the trial judge nor the plaintiff carries the burden of disproving such theories because they are speculative possibilities without any evidentiary support. Not only is this unjust, but allowing the Court of Appeal to theorize potential causes that were not put forward at trial or backed by any evidence, and then suggesting Mrs. Armstrong must disprove them, would create a very dangerous precedent that disadvantages victims in medical malpractice cases. Plaintiffs like Mrs. Armstrong are the parties without medical expertise and are unconscious at the time of the injury occurs.
Counsel, can I ask you, if a plaintiff isn't required to disprove non-negligent causes, aren't we trying to say that surgeons are guarantors of their work? Are we putting the responsibility on them and saying that, you can't have honest mistakes?
No, that is not to our understanding, because I think the difference between an honest mistake and negligence is an issue where it is true that the plaintiff must disprove some causes, but a plaintiff like Mrs. Armstrong, who has demonstrated on the balance of probabilities a theory that has not been disproven by the defendant at all, can succeed and will succeed. And this was proven by Fontaine versus British Columbia. And this was also mentioned in our friend's factum. I think it was at paragraph 15. And it was that essentially the idea that the onus, the burden of proof shifts to the plaintiff to disprove every possible potential non-negligent cause. That does not happen once the plaintiff has established on a balance of probabilities their theory, and there has been no other theory that has been proposed to rebut it, which is the case.
So is it your assertion, counsel, that the defendant has the obligation to essentially an evidentiary burden to bring forward any potential causes that they intend to rely on? Is that your position?
Yes, that is our position.
Thank you.
Thank you. Okay. So, sorry, just continuing. The notion is supported, that we just discussed, by the majority's decision at the Supreme Court in Snell versus Farrell, when it was determined that when the relevant facts are particularly within the knowledge of the defendant, in this case, it would be Dr. Ward, very little affirmative evidence will be needed to justify an inference of causation in the absence of evidentiary evidence to the contrary. Once again, just to reaffirm what was just said, as our friends highlighted on paragraph 15 of their factum, Fontaine versus British Columbia reaffirmed that once a plaintiff has established on a balance of probabilities on a prima facie case, it is up to the defendant to present negating evidence where the plaintiff will necessarily succeed. Justice Van Rensburg, in his dissent at the Court of Appeal, appropriately rejected this mischaracterization of the plaintiff's rule when he wrote, "The onus on a plaintiff in a medical malpractice case is not to disprove every possible theory that might be put forth by a defendant, let alone theories that were not raised at trial but only at appeal. The average plaintiff in a medical malpractice case is not a doctor. It is therefore unreasonable to expect the average plaintiff to be familiar with every way in which their injury could have occurred without these theories being proposed by any expert at trial, let alone by the defendant himself. We respectfully submit the question, how could one be expected to disprove a theory that they did not even know existed? As noted in Danliuk versus Ainsworth Technologies, the law rightly seeks a finality to litigation. To advance that objective, it requires litigants to put their best foot forward to establish the truth of their allegations when first called upon to do so. Respectfully, it is quite evident that Dr. Ward did not put his best foot forward when he failed to propose alternative theories backed by evidence at trial. However, once again, respectfully, it is not the role of the court to theorize possible causes on behalf of him. We submit that it would be a judicial error to set the standard in medical malpractice cases as one where judges can ponder possible explanations not raised by either party and impose on plaintiffs the responsibility to disprove their validity. Moving to my next point, was there any questions on that? Nope. Okay. Moving to our fourth and final point, we submit that the majority at the Court of Appeal erred in applying a correctness standard of review and should have actually applied a reasonable standard of review. While matters of law are reviewed on correctness, matters of mixed fact and law are reviewed on a reasonableness standard. The evidence given by physician experts is a question of mixed fact and law because it involves the application of a legal standard. In this case, the appropriate standard of care for a physician to the medical facts. Matters of mixed fact and law that invoke a reasonableness standard means that appellate courts must defer to the trial judge on their interpretation of evidence. Therefore, the Court of Appeal held the trial judge to an unfair standard by applying the standard of correctness and should have not overturned the trial judge's decision because drawing evidentiary conclusions lie within the domain of the trial judge. Allowing the application of a standard of correctness not only is in direct conflict with the idea of autonomous and integral trial proceedings, but also ignores the expertise of trial judges as those who have extensive exposure to evidence and benefit from hearing the testimony vis a voice. A court of appeal can only refuse to give deference to a trial judge if it is shown that the trial judge made a palpable or overriding error in their interpretation of the evidence. The Supreme Court case, Huson versus Nicolaisen, defines such an error as in the application of a legal standard to a set of facts that is one that is plainly seen and sufficient in vitiating the challenged findings of facts. As my co-counsel Ashley Murray has already covered, the trial judge did not err in the way they articulated the standard of care. The only way to protect the ureter is to stay 2 millimeters away. This is not a goal because on the evidence, there is no other way to identify and protect the ureter, and there was no evidence it was outside Dr. Ward's ability to control staying away. It was surgery 101. This articulation of the standard of care was therefore not a palpable or overriding error on behalf of the trial judge. The trial judge made no error as well in rejecting the potential non-negligent causes for the injury because Dr. Ward's explanation was not supported by evidence. Similar to the case at hand, the trial judge in Hassan versus Anvari deemed possible non-negligent causes presented by the defendant, Dr. Anvari, to be speculative and therefore dismissible because of a lack of evidentiary support. The Court of Appeal deferred to the trial judge on this matter because he was entitled to do so based on a lack of evidence for non-negligent causes. The actions taken by the trial judge in Hassan mirror the rejection of Dr. Ward's explanation due to a lack of evidence supporting them. The difference in Hassan to the facts of our case at hand is merely the refusal to defer to the trial judge. The Court of Appeal's refusal to defer to the trial judge in our case was in direct conflict with the Supreme Court's view on the matter in Hassan when they wrote, "It is not the function of the court to reweigh the evidence or to second guess the findings and facts made by a trial judge." The Court of Appeal decided to give more weight to possible non-negligent theories that were not brought up at trial. The decision to do so does not, however, indicate an error on the part of the trial judge for not doing the same. This notion was supported by the Honorable Court in Salomon versus Matt Thompson when the majority wrote, "The fact that an alternative finding could not be reached based on a different ascription of weight does not mean that a palpable and overriding error has been made. It is obvious the Court of Appeal extended their reach beyond the scope of decision-making power." Deference should have been given to the trial judge because the appropriate standard of care should have been applied was that of reasonableness in light of no palpable or overriding error by the trial judge, not a standard of correctness. To conclude our submissions, we respectfully submit that this court overturn the decisions made at the Court of Appeal and reinstate that made by the trial judge. The trial judge's acceptance that a reasonably competent surgeon would have stayed 2 millimeters away from the ureter was an appropriate decision because it was within the trial judge's power to make, and it was supported undoubtedly by evidence. In determining the standard of care, it was appropriate in this circumstance to use factual causation as circumstantial evidence because no non-negligent theories of causation were brought up by the defense that were supported by any evidence. The trial judge was correct to reject these theories, and Mrs. Armstrong should not bear the burden of disproving every possible cause without evidentiary support either. The decision to not defer to the trial judge would create a dangerous precedent that patients in medical malpractice cases need to be even more knowledgeable in medicine than their doctors. Deference should be therefore given to the trial judge in accordance with the appropriate standard review, that of reasonableness. Subject to any further questions, that concludes our submission. Thank you.
Thank you for your submission, counsel. I believe the bench is just taking notes at the moment. Hi, counsel. I have one question for you. Can you just remind me what your answer to Miss Pacheco's question was? Sorry, Justice Pacheco's question.
That's for me?
Yes, or either one of you.
Um,
She asked, are more or less surgeons guarantors of their work?
No, they're not guarantors of their work. I do not believe that. However, they are responsible for their negligence. Essentially, when it comes to the plaintiff bringing disproving evidence of potential non-negligent causes, the burden is not on them to disprove every potential non-negligent cause that could be there, because there could be millions, really. And if it's not proposed by the defendant, by the doctor at hand, the physician at hand, then there's no way for, or any expert, then there really is no way for the plaintiff to be given a fair chance at trial to
have a fair shot, because they are the ones without any medical expertise or awareness of the situation, are also the ones that are unconscious at the time.
They have the ability to get expert evidence, just like the plaintiffs, just like the defense does, though, right? It's not like they're at this on their own.
Yes.
They're mustering evidence just like everybody else in the trial has to do. So it's not
Right.
really to say, well, you know what, I'm just plaintiff and therefore I'm at a disadvantage because I don't have medical knowledge. I mean, all plaintiffs are in that position unless it's an unusual case where they happen to be healthcare practitioners themselves.
For sure. I guess I probably wasn't clear enough on this point. I think the issue is that the plaintiff did disprove. They did bring medical expertise, and they did bring evidence. On the evidence, 5 physicians, including Dr. Ward, testified. 4, including Dr. Ward, so really 5, did give evidence that whether they articulated that it was exactly the standard of care or not, staying 2 millimeters away was from the ureter was the way to protect it. And no expert, Dr. Ward himself included, gave another reasonable explanation with any evidentiary support of how this injury could have occurred for not having stayed away 2 millimeters. So to put the burden on the plaintiff to theorize on their behalf every possible way, I think at the Court of Appeal, they mentioned, what if an earthquake had happened? And the issue was, well, what if it had? I mean, the plaintiff was asleep. Is the plaintiff supposed to kind of go about their day theorizing, okay, at court, how are we going to do this? Are we going to bring up what if maybe an earthquake could have happened and now we're going to disprove that? There could have been many, many reasons that in any medical malpractice case that an injury could occur. But in this particular case, there was only one, and it was having come too close within 2 millimeters of the ureter. And that was the only one proposed. So it was the only one that was reasonable for the plaintiff to disprove, if that answers your question.
Okay, so just a reminder that we're past the time limit now. So if we're okay to proceed with the respondent's arguments. So the court now invites counsel for the respondent to begin.
Good morning, everyone. I'm Holly Pellatt, and my co-counsel is Veronica Cesario, and we represent Dr. Ward. So in our allotted time, we will establish that the Court of Appeals decision should be upheld by establishing 4 things. First, that the Court of Appeal applied the correct standard of care for medical negligence in Canada. Second, that while in rare cases, causation can be used as circumstantial evidence to inform the standard of care, it was unnecessary and inappropriate in the case at hand. Third, that the plaintiff has a duty to rule out non-negligent causes. And fourth, that the Court of Appeal applied the correct standard of review in this case. So I will first address the first 2 issues, and then my co-counsel will address the last 2 issues. With respect to the standard of care, the Court of Appeal applied the correct standard of care for medical negligence, which is that of a reasonably prudent physician. In the appellant's written submission, they referred to the standard of care as what is reasonably required to be done. And respectfully, that is a misrepresentation and an oversimplification of the law. As demonstrated by the court in Terneuzen and Korn, the standard of care for medical negligence in Canada has consistently been held to be that of a reasonably prudent physician. Additionally, physicians, including surgeons, are not guarantors of their work, and they should not be held to a standard of perfection. A physician is also entitled under the jurisprudence in Canada to make an error in judgment without committing negligence, so long as the error is not a result of carelessness, a lack of knowledge, or a lack of skill. Moreover, when looking at what a reasonably prudent physician should have done in this case, the appellants have respectfully incorrectly submitted that the court should determine what the appropriate course of action was. This is incorrect because, as held in Hirschberg and Branson Drugstore, the court's role is to listen and apply experts' understanding of what was reasonable in a given case, because courts do not generally have the expertise to make the findings in this area without the benefit of expert testimony. Therefore, to correctly understand the standard of care, experts must be consulted. And in this case, the court consulted the expert Dr. Hagen, who testified that he would, in the case at hand, try and stay away from the ureter. Therefore, in this case, the standard of care should have been to attempt to stay away from the ureter rather than the ultimate goal of protecting it.
Ms.
So
Pellatt,
when-
how do you reconcile that with what the outcome ultimately was and the conclusion that the physician didn't stay away from the ureter because otherwise this wouldn't have occurred? And clearly the fact that it occurred demonstrates the failure to stay away from the ureter.
I think we address that in our second point, which that's an issue of causation, which we respectfully submit should be addressed after the standard of care is addressed. So in this case, the standard of care is that they should have attempted to avoid the area, which Dr. Ward testified that he did. So respectfully, we think that causation is not applicable at this stage in the analysis.
But isn't the standard of care to stay 2 centimeters away from the ureter? That's the standard of care, isn't that right?
Well, we're submitting that the standard of care in this case, under expert testimony, is to attempt to stay away from the ureter within 2 millimeters, and that failure to do so can be an error, but not negligent.
Doesn't that lead in part to what could be a ridiculous conclusion in all of these cases where the physician could simply say, I tried to stay away, and in the end, as long as I try, everything's fine. And even if bad things happen, like what's wrong with being able to say, yeah, you tried, but the fact that this injury occurred in this case means you didn't try hard enough, or it's a failure to meet the standard.
Well, I think the threshold that the mistake cannot be careless, nor can it be a result of lack of skill or lack of knowledge, makes that distinction. Otherwise, we're holding physicians to a standard of perfection, which I think you could make the argument kind of goes to a slippery slope in the opposite direction, where we're going to discourage professionals to engage in surgery because of the risk being so high. So if there's no other questions, I'm just going to proceed. In this case, we're submitting that the standard of care was that of the expert, Dr. Hagen, who testified that he would try and stay away from the ureter. And so in this case, when we look at the facts that the trial judge outlined at paragraph 109, he states that Dr. Ward did take the steps during the surgery to identify and protect the ureter. So therefore, we submit that as upheld by the Court of Appeal, Dr. Ward met the standard of care of a reasonable physician as outlined by the expert, Dr. Hagen, and that in order to uphold the current standard of medical malpractice law in Canada, in which surgeons are not required to execute successful, perfect surgeries, but rather act as reasonably prudent healthcare practitioners, Dr. Ward must not be held liable for negligence. Ultimately, to reverse the decision from the Court of Appeal would be to open the door to an attack on the healthcare system, in which our healthcare system would fail to account for normal human errors. It would deter those from entering medicine and undermine the integrity of the healthcare system due to the significant risk in normal surgeries. Secondly, we submit that while in rare cases causation can be used as circumstantial evidence to inform the standard of care, it was unnecessary and inappropriate in the case at hand. So the court has held in Bafaro and Dowd, and again in Randall and Laker Ridge Health Oshawa, that as a general rule, the standard of care and causation are mutually exclusive issues, and causation should not be considered until the standard of care has been resolved. So specifically, the court has stated that the standard of care and causation are separate issues, and that the issue of factual causation arises after the trier of fact has found that the defendant breached the standard of care. So while very rarely it may be acceptable to consider the nature of the injury as circumstantial evidence when it is necessary to fully understand the course of events, this is not the case at hand. In this case,
Ms. Pellatt, why
Counsel,
is
can
that?
oh, my apologies.
Go ahead, Ms. Pacheco.
Thank you. Counsel, in a case such as this one, how would you ever be able to assess as the trial judge that whether or not the standard of care was met unless you know what happened, right? So, and I'll give you an example. If, for example, the ligature was used on the heart, so clearly now this physician has gone way off the map where they're supposed to be going, and I think is clearly now negligent because he's nowhere near the colon anymore. Are we just supposed to pretend that, to not look at that? Like, how do we know that the standard of care has been met or breached? So even met, in any context, how do we know how to evaluate standard of care without determining what happened factually in that operating room?
Yeah, so I think that we're not saying that you shouldn't determine what happened factually. So in this case, the facts are that Dr. Ward testified that he did what he could to identify and protect the ureter, and that was not contested. That was accepted by the trial judge. So we're not saying that that shouldn't be evaluated. What we're saying is that inferences shouldn't be drawn from that in order to use like the standard of care as circumstantial evidence. Sorry, I think you're muted.
Just a follow-up question, counsel. Wasn't it also, I appreciate that was accepted evidence that he made the effort, but wasn't it also evidence accepted by the trial judge that this injury was caused by that, by the ligature coming within 2 centimeters? So again, how do you reconcile that evidence and those 2 pieces of evidence, as you say, that were accepted by the trial judge, and how do you ignore that evidence of cause and fact, which I think, and you can tell me whether or not that's different than causation legally, but how do you ignore that when looking at whether or not he did what he says he was supposed to do? Because, and I'm not saying your client's lying, but what if he didn't? Right? What if he tried but didn't? Or what if he was lying? I mean, in what circumstances are we allowed to look at what happened?
Yeah, I think for us, we submit that cause and effect and legal causation are 2 different things. So for the standard of care analysis, which as the court recognizes is a first separate issue than causation, you can look at the facts holistically and what's happened, but to actually then go on to a legal analysis of causation, those are 2 different things. And so if we are accepting our client's testimony as the trial judge had, that he did everything he could to protect the ureter, he has then met the standard of care that we're submitting, and the analysis should not in that case then even proceed to causation. So if there's no other questions, I'll continue on. So in this case, the standard of care as correctly applied by the Court of Appeal is whether Dr. Ward acted like a prudent surgeon performing a laparoscopic colectomy, and the nature of the injury is not relevant to whether he upheld the standard of care and conducted the operation in a manner that a prudent surgeon would have in the same circumstances. Therefore, while causation can, in some exceptional cases, be used as circumstantial evidence to inform the standard of care, it would not have been necessary in this case had the trial judge applied the correct standard of care. This concludes my submissions for today. If there are no further questions, and my co-counsel will proceed.
May I proceed? Thank you. Good morning. My name is Veronica Cesario, and today I will complete the submissions on behalf of Dr. Ward. As my co-counsel indicated, I will discuss that the plaintiff has the duty to rule out non-negligent causes, and the Court of Appeal applied the correct standard of review in this case. First, I will counter 3 propositions proposed by the appellant. First, the appellant submits that the notion proposed by the majority imposes an unjust standard on the plaintiff by inferring that it is the plaintiff's duty in a medical malpractice case to rule out every imaginable non-negligent cause. Respectfully, the appellant has misunderstood what the majority in the Court of Appeals stated. The Court of Appeals stated that the plaintiff bears the burden to prove that negligence could have caused the injury in question, including ruling out non-negligent causes only in an exceptional category of cases. However, this is not a case that falls within these exceptional categories of cases. The trial judge found that in deploying a ligature within 2 millimeters of the ureter could cause damage by heat transmission, but not always does. In order for this case to be in the exceptional category where only negligence could cause the relevant injury, the trial judge would have had to find that there was no chance of accidental but non-negligent positioning of the tool. Second, the appellant submits that this notion by the Court of Appeal disregards the fact that Ms. Armstrong was unconscious at the time of the injury. They submit that because she was unconscious and is not a medical expert, she is at a disadvantage to rule out non-negligent causes. The appellant also submits that it is not the role of the court to act as researcher and theorize possible causes on behalf of them. Once again, this is a misrepresentation of what the Court of Appeal stated. The Court of Appeal did not create a new duty for plaintiffs, and the court did not require the consideration of facts outside of the trial. The Court of Appeal held that if a plaintiff is bringing forward a theory that only negligence could have caused the injury based on the injury alone, then the plaintiff would have the burden to rule out the non-negligent causes. Third, the appellant submits that Dr. Ward did not put his best foot forward when failing to propose theories backed by evidence at trial. It is not the defendant's responsibility to rule out non-negligent causes. This concept closely resembles the legal doctrine, res ipsa loquitur, that the court in Fontaine and British Columbia rejected. The court reaffirmed that the plaintiff bears the burden of proving on a balance of probabilities that negligence on the part of the defendant caused the plaintiff's injuries. And the invocation of this doctrine does not shift the burden of proof to the defendant. The correct interpretation of what the Court of Appeal stated and what occurred in Fontaine is that circumstantial evidence should be dealt with by the trier of fact by weighing the circumstantial evidence with any direct evidence to determine whether the plaintiff has established on a balance of probabilities a prima facie case of negligence against the defendant. Then the defendant can present evidence negating that of the plaintiff, or the plaintiff will succeed. As my co-counsel stated, there are exceptional cases where causation can be used as circumstantial evidence to inform the standard of care, but that is not the case here. In conclusion, the appellant has misinterpreted the Court of Appeal's ruling on non-negligent causes. The court did not create a new legal burden for the plaintiff to rule out non-negligent causes, and we ask this court to adopt the Court of Appeal's analysis of negligence. I will now proceed to discuss how the Court of Appeal applied the correct standard of review, specifically speaking to 2 points submitted by the appellant. First, the appellant submits that the Court of Appeal erred and confused matters of law and fact when applying the standard of review. The appellant submits that the question was of mixed fact and law. We respectfully disagree. There was an error in law in the trial judge's decision. The Court of Appeal applied the correct standard of review in this case. The Court of Appeal identified that the trial judge imposed an improper standard of care when measuring Dr. Ward's liability. The Court of Appeal found it was an error of law to use outcomes or goals as the standard of care, which the trial judge did. On a pure question of law, according to Hussain and Nicholson, the appellate standard of review is that of correctness. The trial judge measured Dr. Ward's negligence by inquiring whether Dr. Ward succeeded in not coming within 2 millimeters of Ms. Armstrong's ureter with the ligature, instead of asking whether Dr. Ward took the steps that a reasonably prudent surgeon would take. In finding that this standard of care was not correct, the Court of Appeal used the appropriate standard of correctness. Second, the appellant admits that by the Court of Appeal looking at the standard of care, it was a question of mixed fact and law. This is not correct. Justice Mulligan's decision was the result of his error on the articulation and application of the standard of care for medical negligence in Canada. This is an error of law, and the Court of Appeal applied the correctness standard. In conclusion, we submit that we have established the following 4 points. The Court of Appeal applied the correct standard of care for medical negligence in Canada, and that while in rare cases, causation can be used as circumstantial evidence to inform the standard of care, it was unnecessary and inappropriate in the case at hand. The plaintiff has the duty to rule out non-negligent causes, and that the Court of Appeal applied the correct standard of review in this case. Therefore, we respectfully ask that this court dismiss this action against Dr. Ward and uphold the Court of Appeal's decision. This concludes my submissions if there are no further questions.
Counsel, was Was there any evidence at all that this injury could happen if you followed all the steps?
I believe in the trial judge said it could, use those words that it could, that if you take all the steps, it could happen, but not specific evidence.
Counsel, you spoke about how sometimes we can infer the standard of care from the actual events that occurred. And then you said that this is not the case here. Can you please explain clearly again, maybe I missed it, why this is not the case here?
This would not be the case here if negligence was the only way that this injury could have been caused. And since the trial judge said that it could have been caused in other ways, then this case doesn't fall into those exceptional cases.
Is the standard not on a balance of probabilities?
It is, but we submit that the standard that the trial judge applied the incorrect standard, and if they had applied the correct standard, then it wouldn't have made it to the causation step of negligence.
And you're saying the correct standard was purely a question of law in this particular case?
Yes.
Counsel, can you explain to me how it is that the application of the standard of care is ever just a matter of law? Isn't it always going to be informed by the facts as found?
We believe the application would be, but the description of the standard of care, which we believe the trial judge set too high, we believe he set a standard of perfection. That was the incorrect part of the trial judge's decision, and the Court of Appeal ruled on correctness on that standard. If there's no further questions, that is the end of my submissions.
Just to confirm that there are no further questions before proceeding with the rebuttal. Okay. The court now invites counsel for the appellant to begin their optional 3-minute rebuttal.
Thank you, everyone. First off, we would just like to thank everyone for hearing our submissions today. We'd also like to thank our friends for respectfully raising their views on the issues at hand. First off, what we would like to address is the fact that the respondent submitted that a physician can make an error without committing negligence. This is true. And if Dr. Ward had explained that he came within 2 millimeters, but had a reason that this was a mistake, the trial judge would have weighed that evidence accordingly. He did not. Dr. Ward did not submit this evidence. He only offered that he stayed perhaps 15 to 5 centimeters away, which was rejected based on the evidence of thermal injury. This was evidence provided by 5 expert physicians. Secondly, upholding the standard of care in terms of trying is a very slippery slope, and it's very concerning. Attempts, which is how our friends on opposing counsel articulated the standard of care should be, is a very dangerous precedent to set for doctors. Attempting to adhere to the standard of care is not what is required, and it should not be what physicians are attempting to ascribe to and model their practice on. It should be actually meeting the standard of care, which was staying at least 2 millimeters away from the ureter. Merely trying could be a defense for anything that occurs, and this would be a very problematic precedent to set. Further again, this would be an attack on our healthcare system. That argument raised is not true. This was surgery 101, and every expert testified that staying 2 millimeters away from the ureter was important because of thermal spread. Not reinstating the trial judge's decision would, however, be an attack on the plaintiffs in medical malpractice cases, who would now have to become better experts in medicine than their physicians and every expert called to testify. We would also like to touch quickly on the category of exceptional circumstances which our friends brought up. Categories of exceptional circumstances are where it is obvious that the injury was without a doubt caused by the defendant during surgery. During surgery, the plaintiff ought to bring evidence to rule out non-negligent causes. Whether this is an exceptional circumstance in our case is very besides the point, because the plaintiff's rebuttal to the non-negligent cause raised by Dr. Ward, which is that he did somehow stay far away, but the injury still occurred, was supported as articulated in the statement of facts in our factum by at least 4 expert physicians and also pointed to by Dr. Ward himself. Finally, we would also like to touch on the issue of mixed fact and law. Our friends on opposing counsel argue that this was a issue of pure law. Mixed fact and law issues are determined on the facts and the standard. They're not determined on an alleged mistake made by the trial judge. The issue of palpable and overriding error comes in after the standard of review is established and has the capacity to change a standard of reasonableness to one of correctness if an error of such is established. However, palpable and overriding errors, as we have previously submitted, are very obvious and they change the findings of facts completely. None have been made like that in our case. There have been no palpable and overriding errors by our trial judge. He was correct in his articulation of the standard of fact as presented by my co-counsel, Ashley Murray, and he was correct to reject the evidence provided as it was not supported by any real and plausible evidence. We are happy that our friends do agree with us that the plaintiff does not have a duty to rule out all potential non-negligent causes once they have proven on a balance of probabilities that they have a theory of negligence and there has been no other reasonable defense to that. We would like to thank the court for hearing our submissions today. And with that, that concludes our rebuttal. Thank you very much.
Thank you very much. So this concludes the matter of Armstrong v. Ward. Congratulations, everyone. At this time, I would like to invite everyone, if possible, to remain for the next session, which will begin at 11:30 a.m.
Thank you.
Thank you. Thank you to council.
Thank you.
Thanks, everyone.
Thank you.
Thank you very much, council.